this case, my lord, I seek my lord 2 weeks time to file my lord done. Reply of the
Mr. Enforcer, I don't allow this type of prayer.
Already that has been prepared, my lord. Only we have not come for side. Only 1 week, my lord.
Counsel appearing on behalf of the petitioner seeks for an accommodation. Interim order. Taking into account the above, list this matter again on 24th of August 2026.
It is not regarding I first 1822. We are filing our activity of which the now this is the private question of the
Where? Listed.
listing for admission hearing.
What the matter about?
Regarding not to the contract of
Information item 29 and affidavit in reply has been filed. Thank you.
29.
Item 29.
What is that? You are appearing for?
Number
29.
it's connected letter with item 28.
These are matters which are connected. We have to look into it. Don't mention.
Lordship, it's for the record to bring it on record.
You want to
Yes.
bring some affidavit on it?
Okay. Item 18.
Is that? Why?
Respondent for have filed it, but minutes behind and filed it.
regarding the
No state.
they have started with the lecture of that point they have come.
It has been brought to the attention of the court that the respondent brought to the attention of this court that the Industries and Commerce Department of the Government of Assam had filed the affidavit today. The counsel appearing on behalf of the petitioner submits that the copies have been received. And the petitioner would like to inquire as to whether they would like to file a reply there against. This the matter on 7th of September 2026. In the meantime, reply be filed on behalf of the petitions. You have also filed where?
1 month before.
Please, Your Lordship. We are going to withdraw this petition, but I have not received the written instruction by kindly fix it on Monday or Wednesday, my lord.
What is this?
This is against the Lok Adalat, my lord. Order of the Lok Adalat. Because we have already paid that complying the order of the Lok Adalat, my lord. So kindly fix it Monday or Wednesday, my lord. We are going to withdraw, my lord.
No withdrawing.
Yes, my lord.
Miss Again, the remote CDC submits that she has received some telephonic instruction that the petition will be withdrawn. However, she submits that without a written instruction, the petition she will not in a position to make that submission. Accordingly, list this matter again on next meeting.
Must have been.
Yes, the respondents have filed their affidavit on 27th May 2026, which taking. And page 19 is the communication addressed to the senior serving council. And page 20, the commission, the secretary finance department.
So what?
We have also already stated in page 20 that refers to the subject stated above, I am directed to existing to include fund provision amounting to rupees 21,92,000 only in the budget provision of chief discretionary department and the financial year 2026-27 in order to make payment to Monji Dolmari, which is the petitioner pertaining to Susu. So they have already admitted that and the work was completed in the year 2018.
So here the petitioner is entitled to the amount of 21 lakhs 92,000. Now the question is for making payment. My question is, the direction is to be paid as per Kamserali. If it is to be paid by Kamserali, then you must be having his name in the chronological list. Where is the chronological list?
As per my instruction, Lordship, in some of the contempt cases, what the judicial authority is doing is that they are paying the liabilities at one go entire year, Lordship. Some of the contempt cases.
I'm not on that. My question is, there is a direction to pay as per Kamserali.
I'm sharing, Lordship.
If it is to be paid as per Kamserali, you have to maintain a chronological list. What is the status of the petitioner in the chronological list?
Lordship permits me to take instruction on that, Your Lordship.
Monday.
Maybe next Friday, Lordship.
Why? It's very far off.
Chronological list was there, Lordship. Chronological list was there with the earlier GC council.
So there has to be, you see, the moment you have found that you are entitled to 21 lakhs 92,000, the payment has to be made as per the chronological list. Now, where is the chronological list? Mr. N.R. Sharma, the learned counsel who appears on behalf of the respondents, is directed to produce the chronological list so maintained by the BPC department for payment of the dues to the contractor in terms with the judgment of the full bench. In the case of Aksar Ali versus so-and-so, reported in so-and-so. It is also noticed that the respondents duly admit the petitioner is entitled to rupees 21 lakhs 92,000. The said chronological list shall be produced on 15th of May 2026. What is it, Mr. Boy?
Compliment your thought.
That I know what has happened.
That instruction, let it take next week, I've already communicated with them regarding the status.
Mr. R.R. Gogoi, the legal counsel submits that taking into account that recently the elections of the Legislative Assembly, the results of the election, the results of the some legislative election was announced on 4th, and there is a likelihood of formation of a new government. Some more time is required. Taking into account the above, this matter again on 22nd of June 2026. In the meantime, as per the assurance given to this court by the order before this court on 7/3/2026, the respondents herein are directed to clear the amount to which the petitioner is entitled to disburse the amount to which the petitioner is entitled to. Failure to do so, this court may be constrained to impose interest upon the respondent departments, and such amounts shall be recovered later on from the salary of the carrying officials.
So here, as for reports of the dated 3rd of December, we were required to file a comprehensive affidavit. Lordship, we have sent it for a vetting, but the mission director is on election duty at Tamil Nadu. He will be returning on Monday. Lordship, may allow me just for 5 days.
It's the beach agree, the learned counsel hearing on behalf of the SSA submits that within 4-5 days, the affidavit will be filed. Taking into account the above, this matter again on 25th of May 2026. Affidavit be filed on or before 18th of May 2026. The matter be thereupon listed for admission.
Therefore, 7 days time, passenger speaking. Some report they have got, they will pass this to power. Regarding the claim for contractual. It will be passed by the MD minor NHA.
An application filed alleging willful and deliberate violation to the order dated 17/2/2025 passed in application number 1448 of 2025, whereby there was a direction upon the respondent number 2, that is the Mission Director, National Health Mission, to consider the representation within a period of 1 month and thereupon intimate to the petitioner. On account of not taking steps and on account of the representation of the petitioner being not considered in spite of specific directions passed by this court on 17/3/2025, the present contempt application has been contempt proceedings have been initiated. Mr. B. Gogoi, the learned counsel who represents the mission director, submits that within 7 days, the order, the speaking order in respect to the consideration of the representation of the petitioner would be passed. Considering the above, this court fixes this matter again on 27/25/2026. So the speaking order, the respondents are directed to do the needful. Failure to do so, this court may be constrained to pass appropriate directions. The service upon the respondent number 6 being not complete, list the matter upon completion of service upon the respondent number 6. Yes. For whom are you appearing?
Yes, my lord, yesterday, my lord, I have filed my lord, wakalat number 4178. Wakalat number, yesterday, as per your lordship last order, I have filed wakalat number, my lord, pertaining to 178 number of respondents. Chronologically, this is the
How many respondents you have filed the wakalat number?
178. We are led by senior counsel, K. Bakanta.
Oh, so you are appearing for everybody?
Yes, that is the list, my lord.
Because there were 204,
145.
of which there are a lot of people whose service is not done. So therefore, service is complete.
This is complete, no, my lord, there are some other respondents, my lord.
No, you see, the question is here, the service is not complete only in respect to these persons. Kindly come to paragraph number 6 of my order.
Yes, my lord.
And regard response number 9, 16, 17, 19, and are you appearing for the people? At paragraph number 6.
Nine, I am not appearing, my lord. 16, I am not appearing, my lord. 17, I am appearing. Then, my lord, 19, I am appearing. 20, not appearing. Then 25, 26, I am appearing, my lord. 35, I am appearing. Then 46, not appearing. Then 50, 51, I am appearing, my lord. 52, not appearing. 54, I am appearing. Then, my lord, 57, I am not appearing. Then, my lord, 65, I am appearing. Then 91, I am not appearing. 94, I am appearing, madam. Then 106, I am not appearing. 113 also, I am not appearing, madam. 115 also not appearing. Then, my lord, 131, my lord, I am appearing. 134 not appearing, my lord. Then 151 also not appearing. Then 163 also not appearing, my lord. Then 183 also not appearing. 208, my lord, I am appearing. 209, my lord, I am appearing. 213 not appearing, my lord. 217, my lord, I am appearing. Then 232, my lord, not appearing. Then 242, my lord, I am appearing. And then, my lord, 251, I am appearing.
And 62, 105, and 190.
162, yes, my lord, 62.
So there is no necessary, they have refused to accept, so therefore it's complete. So as regards,
62, my lord, I am appearing.
anyway, they have refused. So we are only concerned with where you are not appearing. How many are there not appearing? Where it is not appearing? 12.
Now, well, so far as 62, 105, and 190 is concerned, who have refused, but I have filed wakalat now. So for
Okay,
60,
but otherwise the service is complete and they have refused. I've already passed it on.
Yeah.
So therefore, we are concerned with these 12.
yes, well, if
These
there,
12 extra copies they are going to make and give it to them. And they will use it. So these are the only 12 left.
so far as para 6 observation is concerned.
So others we have duly received. And there are now you are appearing for 178. That means 12 is not being represented, means 190. 190.
Because my lord, in this petition, there are
190. There are how many respondents?
altogether 252 respondents. R1 to R7 are the official respondents. From R8 to R252, these are the private respondents. Totally,
What has happened to those remaining 52?
they have, my lord, some of them are also approaching us, my lord, but not having handed over the power till now.
Okay, but the question is, what happens is, because notices have been delivered to, okay. Notices have been delivered to the respective, so these people. You are not appearing for 155.
One, my lord, 155. 155, I am appearing, my lord.
Are you appearing for 33, 60, 68, 82,
33, we are appearing, yes, my lord.
60,
60 not appearing, my lord.
68,
68 appearing, my lord.
82,
82, my lord, yes, appearing, my lord.
101,
101 not appearing, my lord.
107,
Yes, my lord, appearing.
144,
144, yes, appearing, my lord.
202,
202, my lord, not appearing.
241,
41, my lord, yes, appearing, my lord.
তো এইটা সমর্থন এটা নাই এপিয়ার কর এটা না না সেইকেইটা নহয় এই লাষ্টৰ এই পাঁচটা হা এই নম্বৰ কেইটা লিখিছিল কোনকেইটা দিনত
My lord. Two not appearing, my lord. Two is not appearing.
So 60, 101 and 202, you are not appearing.
Two not appearing. Otherwise, my lord, in the list, my lord, that we have provided to the honorable court, the kindly produce the list, my lord. Here in the first column, lordship will see, my lord,
You are not appearing for 252.
252 not appearing. Total, my lord, we have filed power for 178 respondent. And in column two, lordship will find, my lord, we have arranged the respondent numbers, my lord, in ascending order. And this list, my lord, we have also
No,
submitted.
we don't have, we have still 252.
Therefore, my lord, from R1 to R7 are.
So there are in total, means 7 into minus 8, it will be around 245.
245.
So there is 245.
From R8 to R252, it is 245.
245. And you are appearing for 178.
178 as of now. And another 4 my lord already power has been filed, my lord.
Apart from that,
Apart from this.
the 2,182.
Yes,
And they are already appearing for 1451.
yes, they had it. That's what my lord I am submitting. 13 is also included.
31. 31. They are
Yes.
already appeared for 14
Yes,
and
yes,
51.
31 already appeared.
And one Mr. T. Sinha appears for 40.
Yes, my lord. Yes.
So how many copies would be there? You make these extra copies for whom they are not hearing in respect to those respondents. So we to, you know, he'll get itself. That's what we have already find out, we do find the reply. Therefore, we can proceed to the
This may be given person.
And how many people are you? 4. You are working as what? Are you working as PP?
No. No, we have applied for.
Okay, you are not working for PP. And what about the other matters of PP? There are some few other matters where for PP.
There I have appeared.
No, understood, but there are some other matters of PP. There's a challenge that regards somebody is challenging on pay on the question of PWD. Because out of something around 287 posts or something, you have only filled up 204 or something or 240. 242. Ah, 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 ah. That is what we have recorded in the. Now we have already dealt with that in the infrastructure bench. Infrastructure bench we have dealt with, and there is an affidavit being filed by the Home Department to that effect. And we have included and mentioned that aspect of the matter. Okay. So as regards the others, Mr. Counsel, you have to be more proactive. As regards the others who have, they are not appearing and where service has not been complete, find it out from them. Page. There's only one WPC before. Then you don't know anything. Where's your another council? Get hold of another council. You don't seem to be responsible. You don't know and don't make mistake appear out there. Where's the other councils? Who are there? Let us dismiss this petition for default. Absolutely, you don't know anything. Don't come up before this court, don't knowing. Mr. Saik, I want to dispose of the matter as early as possible, taking into account what is happening. You see, what this litigation is having an impact on the others, where we are taking up on the infrastructure bench. The matter needs to be resolved as soon as possible because there should not be a shadow lingering upon these newly appointed. They have also left their professional careers and now joined the services. So therefore, we need to, yes, and I'm also aware of the fact that being there in the you call somebody, you are of no use. Get hold of any better counsel on the petition. Now, because you see, I'm also there in the Judicial Academy and I have found out that there's a huge amount which is also being charged by the Judicial Academy for training. All these things should not go to waste now. Mr. Chaudhary, Mr. Arba Pujari is appearing for around 178 persons.
Really?
No, virtually, but then also I don't want to keep the loophole.
Yes.
Now, can you ask one of your juniors, not him, he's not in a position to do it.
Yes.
Ask one of your juniors to just correlate and give extra copies to Mr. Dina so that the service could be completed
Yes.
through the government as regards to.
They will give me that.
Heard Mr. K. N. Chaudhary, the learned senior counsel, assisted by Miss R. Kapoti, the learned counsel, appearing on behalf of the petitioners. Mr. D. Saikia, the learned senior counsel, engaged by the government of Assam, assisted by Mr. D. Nath, the learned senior government advocate, appears on behalf of the respondent numbers 1 to 7. Mr. P.P. Doctor appears for the respondent numbers 14 and 31. None appears on behalf of the respondent number 40, in spite of Wakalatnama being filed by one counsel, namely Mr. D. Sinha. Mr. Arba Pujari, the learned counsel, had submitted that he has already filed power in respect to 178 private respondents, and the list have been provided to this court pursuant to the order passed by this court on 5/5/2026. From the above, it is seen that there are still some respondents upon whom service is yet to be met out. The learned Ms. R. Kakuti, the learned counsel who assists Mr. K. N. Chaudhary, shall make necessary verification of the list so provided by Mr. Arbor Pujari, along with and compare the same with the office note dated 4/5/2026, and thereupon serve extra copies of the writ petition in respect to those respondents, private respondents who are yet to be served to Mr. Dina, the learned senior government advocate. Mr. Dina, the learned senior government advocate, now, taking into account that the private respondents are now discharging their duties pursuant to their appointments, Mr. Tinath, the learned senior government advocate, shall, through the respondent department, effect service upon those respondents who are yet to be served. First, list this matter again. And we have it on 15th of June. 15th of June. Can you then all complete the pleadings? You have filed your affidavit. Now you have filed your affidavit. So the private respondents will file the affidavit when? Then I think this matter has been tagged with me. So therefore I am not here till 5th of June. I'm not here. So we can have it on 11th or 16th of June. So list the matter on 11th of June 2026. The private respondent shall complete their pleadings on or before 29th of May 2026. Liberty given to the petitioner to file reply thereagainst on or before 8th of June 2026. So, taking into account that the issue involved in the present proceedings touches on the functioning of the courts, it is the opinion of this court that the matter requires an urgent disposal. Accordingly, an attempt shall be made to dispose of the writ petition on the next date.
Regarding item number 6, I was not able.
40. Ready? But there is a wakalat nama. No, you see, then if he has withdrawn, then the petitioner knows, na? The respondent knows. The respondent knows that he has withdrawn. So therefore, either he has to show, he cannot, no lawyer can come out here and say they have withdrawn. That has to be with the concurrence of the court. Concurrence of the respondent, the concerned respondent. So anyway, take it up. What is there? Do something.
Lordship, may I interrupt for 1 minute?
Mr. D. Sekia, are you there on 12th? Yes? Oh, 12th you have a problem. Okay. Anyways, there's one matter which was there. I'm taking up this forest eviction matter. So there were some affidavits being filed. And although I had reserved the judgment, then later on I found out that in one of the forest reserve, there was no affidavit filed. So they have taken time, and today I think they will be filing the affidavit, and I've taken up for final disposal on 12th. And in that matter, 13th or 14th. Anyways, we'll see on 12th how it works. Because there is one issue which is there. A correlation now, you see, prior to 1980, those people who were there in the forest after being allowed by the competent authority, the government's Assam Forest Policy 2004, read with the present Assam Forest Policy, provides says that they should be also considered outside the forest somewhere for the government. So that is an aspect which needs to be looked into. Although Mr. Parangang Goswami is appearing as an additional AG, but he's also appearing for the forest. So if anybody is there from the revenue, appears out there, because that is an issue which needs to be looked into, because that is the government's policy. Although there is nothing to be done as regards the reserve forest is out. But how do you tackle those persons, because it being a policy of the government? I'll with Rajiv Borku that you'll be there on that day. There is a long list of the matters which are there on 12th. So be there. I put it on top of the 2 p.m. I put 2 p.m. I put.
Regarding item number 6, my lord.
Item number?
6, my lord. It's already
What is
got-
that?
There is an interim order, my lord, to be continued, my lord. I was not able to be on time.
No, nobody has appeared on behalf of the petitioner. Can't help you. Come at the end of the day, then I can help.
That's okay.
Not now. What is the matter about?
They are challenging a speaking order, Lordship, passed by the PCCF, whereby the appeal of the petition dismissed. It's regarding this, final concession area, Lordship. Concession area, mineral concession area, the default of payment of pay.
On the last occasion, the petitioners may be granted as she has no instruction in the matter. Because none has appeared on behalf of the petitioner on call. Mr. R.R. Gogoi appears on behalf of the Forest Department. Post. Mr. R.R. Gogoi, the learned counsel, appearing on behalf of the Forest Department, informed this court on 27/4/2026 that the instant writ petition had already become infructuous. Under such circumstances, this court inquired with the learned counsel appearing on behalf of the petitioner as to whether anything further survives in the present proceedings. The learned counsel for the petitioner, as has been recorded in the order dated 27/4/2026, sought for a further opportunity as she has no instruction in the matter. Taking into account the petitioner has not represented today, it appears that the petitioner have lost interest in the proceedings for which the instant petition stands dismissed on non-prosecution. What is this? Non-payment. What is your stand? Paid. What do you want?
Extra amount is required.
Huh?
Not required. It's,
You have completed the work
7,900.
and executed 50% of the allotted work under the work number year for which payment of so and so was made. And there was allotted the work for a month. Value of the work was so and so 50%. So you have been paid only 50% because you have done 50% work.
I annexed it after 12 years, I annexed the photo also. I complete the work, it takes
When did you do the work?
2012.
And how is the repetition maintainable in 2022? To dismiss it on that, no.
No, I separate representation.
So
They
what?
said, yet to-
Representation does not enhance the period of limitation. We dismiss it on that count.
Another case, similar case of the disposal.
Those are good judges, not me. They don't- Division bench heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Ms. P. Chakraborty appears on behalf of the Water Resource Department. The present writ petition has been filed by the petitioner claiming an amount of rupees 2,86,900 along with interest from the date of completion of the work order. It is relevant to take note of the brief facts which led to the filing of the present petition. The petitioner was issued a contract for construction of F/E along L/B of Digaru from N National Highway to Kurkuria Hill. The total contractual value was rupees 2,86,900. The said work order was issued on 24/12/2012, and the work was to be completed within 30 days from the date of issuance of the work order. The record reveals that the petitioner had submitted some representations, and the last of such representation enclosed to the petition is of the year 2018.
19.
18. What 19? Page 21. Thereupon, after 10 years from the date of issuance of the work order, after more than 10 years from the date of issuance of the work order and the alleged completion, the petitioner approached this court by filing a writ petition on 14/11/2022. This court had issued notice returnable by 6 weeks by an order dated 25/11/2022. The record reveals that an affidavit in opposition was filed by the respondent number 3 on 29/1/2026, wherein it was mentioned that the petitioner was issued a contract work order on 1/2/2012, and the value of the work was rupees 2,49,301. As per the records which was available with the department, the petitioner had executed about 50% of the allotted work, and payment was made to the extent of rupees 1,24,651. It was also mentioned that there was no pending liability against the petitioner. In addition to that, the bill of payment of the amount to the petitioner have been enclosed as Annexure 1 to the said affidavit in opposition. Considering the above, it is therefore the opinion of this court that as the respondents categorically mentioned that the petitioner have only completed 50% of the work and all pending dues have been paid, the question of entertaining the incident with petition under Article 226 of the Constitution, thereby directing the respondents to make further payment, does not arise. In addition to that, this court finds it very pertinent to observe that the petitioner was issued the work order in the year 2012, and the petitioner was required to complete the work within 30 days. The entitlement of the petitioner therefore arose sometime in the year 2012 itself. The petitioner barely by filing representations before the authorities. The period of limitation cannot be enhanced. Would not merely filing here. The delay and lapses on the part of the petitioner to approach this court cannot be condoned. Accordingly, this court does not find the present petition to be a fit case for being entertained under Article 226 of the Constitution, for which the petition stands dismissed.
It's like this, your lordship, 2012.
Name, dismiss.
Your lordship, I'm only lying on the judgment.
Oh, I'm not going to rely on anything. Anything you go on division bench. Division bench let it correct.
Only one page, but there was
No, nothing doing.
nine, 10, 11. Surya construction. Paragraph, relying on paragraph number 3 and 4.
No. Does it say anything about the delay?
So yeah, Lordship, paragraph number 4, your Lordship, that this being the case, the work having been completed long back in 2009, with idea Uttar Pradesh Jal Nigam to being an essay taken in a period of 4 weeks. Paragraph number 4, your Lordship. Although there was.
So, no. You see, there were many orders passed by the High Court. The High Court passed this order on a contempt in 2013. Then,
Consider.
nothing. It doesn't matter that dismiss is right away.
Number 9, 10, 11. 11.
For dismissal. Where is the work order?
This is, Lordship, the work order is not, I'm not against the work order.
Then how will they find out? Tell me.
Next, one,
Work order, there is nothing out there. Doesn't matter, doesn't happen. It's the leniency of the court which is resulting here. So here, because of this paragraph, you are entitled to, that they have duly admitted.
it's, it everything.
You should not have filed the affidavit. I think the affidavit you have spoiled your case. No. Or Mr. T. Devi Dillon, counsel appearing on behalf of the petitioner. Miss. Each property appears on behalf of the Water Resource Department. And you are paying for it? When to appears on behalf of the Union of India. The petitioner herein has approached this court seeking a direction upon the respondent authorities to release the outstanding amount of between 1,13,857, which was payable to the petitioner. It is seen from the reports. It is seen from the enclosures to the petition. That the entitlement of the petitioner of rupees 1,13,000 857 is on account of two work orders which were issued in the year 2012. The record further reveals that after 11 years, the petitioner had approached this court by filing the present petition. In the opinion of this court, the instant petition ought not to have been entertained merely on the ground that a representation was submitted by the petitioner in the year 2023 and thereupon approaching this court. Be that as it may, the learned court bench of this court had issued notice by keeping the maintainability of the petition open. The record reveals that the respondent number 2 had filed an affidavit in opposition, wherein at paragraph number 7, 8, and 9, the amount of rupees 1,13,857 have been duly admitted to be the balance amount payable to the petitioner. Taking into account the same, paragraph number 7, 8, and 9 of the said affidavit in opposition is reproduced hereunder. The above admitted, the above admission on the part of the respondents in view of the above admission on the part of the respondents, this court finds it pertinent to observe that it would be inequitable in exercise of the powers under Article 2 to 6 of the Constitution not to direct the respondents to release the amount to which the petitioner is entitled to. Accordingly, the petition stands disposed of with the following observations and directions. The respondents herein are jointly and severally liable to pay the amount of 1,13,857. But the said amount be paid to the petitioner within a period of 6 weeks from today. And failing to do so, 6 weeks from the date a certified copy of this order is served upon the respondent number 2. And failing to do so, the said amount shall carry interest at the rate of 11%, 18%, 18%, 11%, 8%, 8% per annum. It is further observed and directed that the interest so payable, which will be payable upon completion of the 6 weeks, on account of non-payment of the amount within 6 weeks, as per the direction above, has to be paid by the respondent departments, and the same shall be thereupon recovered from the salary of the erring officials.
Very good.
Item 10, 11, and 14 of the same, madam. They say under the same,
You have filed the affidavit.
yes, madam. Same project.
They say that they don't have funds. So you do whatever thing like after 11 years, if you admit to this, yeah, then you should have raised the issue of maintaining it. You have not. So otherwise, I normally give 6 months. I'm giving you 6 weeks. And there will be interest that will be 8%. And that will be deducted from your You show them that you have already paid. You fight it out amongst yourself. Otherwise, say that water source we are not going to sponsor. Do that. But you see, you are sponsoring the water source. And water resource is not taking the payment. They are swindling away that money. And thereupon, when the matter comes, they always take a plea out there that here we have not got the money. Petitioners have been harassed, right, left, and center. Although you have been illegal, there's no parallel that you have not been illegal. But water resource department is doing that. So therefore, you say that water resource you are not going to Assam, you are not going to sponsor anything. Let them work.
But I have the updated version. We have not released the fund balance.
And
But then
you
we will talk about
you
that.
pick it up. Otherwise, you know what it is. Therefore, I say all the respondents are jointly and severely liable. Then you deduct the increase of 1,18,000. Understand? No. In the 2012, if you have all the documents available, then why didn't you make the payment for the last 11 years?
What
13 years?
department we can receive funds from the
Are
central
you
government?
saying that you have not received funds? And you say that you have paid the funds?
They have some confusion. They have filed some affidavit, but this means that they have not released the fund from. I have the latest instructions with me.
You do whatever you feel like. Otherwise, pay interest to the information. Yes, madam. What happened? Affidavits filed?
Affidavit filed, will reply also.
Huh?
If possible, today, I'm not ready for an argument also. Right? So I coming that I get it, see them.
You met with an accident.
Not apply by.
Mr. P. Sharma, the learned standing counsel of the Fishery Department submits that he met with an accident. And as such, is not in a position to argue the matter. Considering the above, how long will you like to take
Any
time
record.
for be recovering?
Even in the evening also, that's lots of blood come out.
When? You will require another 5 liters of blood.
No blood yet.
Okay, leave the matter after vacation. There's an interim order, huh?
Yes.
Taking into account the above, list this matter on 17th of August 2026.
Too
Interim
long, Lord.
order passed earlier.
It will be too long, lots.
Okay, have it on 7th of September 2026. Order passed.
August, okay, then August.
17th of. Interim order. Yes, what is this? On payment of what?
Protection construction of.
What do you say? As per you, what is it? Are you
There,
admitting?
there will be a joint verification on 11th of May and 12th of May. Petition has been intimated. So whatever is the admissible amount, it will be there thereafter. Let it be matter after 4 weeks. What we see my instruction. Some work was executed in Assam Bhavan, Salt Lake, Kolkata.
Oh, that one.
That one, yes.
There was some
Yes.
going on, huh?
On 11th of May and 12th of May, there will be verification regarding the work. So it may be posted thereafter.
Mr. B. Gogoi, the learned additional AD Assam submits, who also appears as the standing counsel of the PWD, submits that on 11th and 12th of May 2025, there is a verification of the works done by the petitioner. And therefore, some more time may be granted. Accordingly, this matter again on 22nd of June 2026. In the meantime, the respondent, the petitioner party shall try to settle out the disputes.
Lot. What?
But the petitioner is on the way. He requested me to pass on, please, it's coming. Kindly sit in his company.
What is the matter about?
Sir, actually, I do not know.
No.
He requested me phone. I'm coming here for.
Yes, the petitioner is there. What is it? What are you asking for? So you are asking them to put you in that list, but as a proprietor. Change in the constitution. Then
Lordship, that's as per our lordship, contract manual, lordship, it cannot be done because there's a private case pending and government rules. Until and unless this firm clears these things, it cannot be changed as per contract. manual.
Your Lordship, I have also counterclaimed against this, particular this conflict. And the arbitration proceeding is on way, and here I want to submit. My counterclaim and the.
No, the fact remains. It was a partnership firm.
Yes.
Once it is a partnership firm, the partnership having been dissolved, nothing remains. He has to be raised separately as the proprietor.
This country, name of the firm to be same,
No.
he is, cannot be, want to be the proprietor of that firm now.
No, that whether you have taken that name or not, you have to register separately.
That, on that he has to submit his affidavit.
No, the question doesn't arise because the entity is different. Earlier it's an entity under the 1932 Act. Now you are a proprietor, you are the owner. Maybe in your name or you will be using that name, the trade name. Whether that trade name you are using it, you have to register it separately as a proprietor. No case.
No, Your Lordship, just
No
a minute.
case.
There is a case, Your Lordship, or any change in the constitution, we have to get the permission.
Whatever may be, you have to get it yourself registered.
Your Lordship.
Yes, it will be a different thing. You may very well claim that the benefits of this particular or the experience be taken into account while you are bidding. These are things which may be taken note of. But otherwise, no case.
Your Lordship, primarily this firm was proprietorship firm. Then it was converted into partnership firm with the consent of the department. Now one of my partner was my missus who is expired. Second one, he has withdrawn the partnership. So now as per the contract manual, I am allowed to convert it again into a proprietorship. And that is as per their constitution. And for that, if you go through the case, I have given all the required document and they have accepted it. And their only claim in affidavit in reply that there is an outstanding against me. But that case is there in the arbitration process. And here in this particular case for which they are claiming that they are having some dues, I have also counterclaim. And other than that, there are two other arbitration cases that is going on in which I have the claim, the government don't have the claim.
Even in the counterclaim, in your claim, in the arbitration proceeding, tell me how are you going to enforce if you don't change his name?
But the firm will bear lot. We have to take it from the firm because as
How? The firm is dissolved.
It is not dissolved, Your Lordship.
Obviously, it is dissolved when it becomes a partnership, a proprietorship, no longer a partnership.
As
firm is dissolved.
as per their manual, we can convert it into proprietorship or and then in partnership.
Maybe that is not heard of. That's all. The firm, the moment the person dies or there's no partner of the firm is dissolved. Once the firm is dissolved as per act, as per law, you cannot continue an arbitral proceeding against him.
Yes, sir.
So if he continues out there, he cannot continue as the firm.
As a form,
He cannot continue. He has to continue as a proprietorship. Or say that this has the owner told me. Something is to, there has to be an assignment. Without an assignment, it cannot happen. This will be a case under the CPC and the other 2210.
But Lordship, in this case, they have the claim. They have filed the petition. My contract was cancelled and they have the counter claim. And for that, I have the counter claim also.
Understood, but the reason why you are not doing doesn't seem to be proper.
my instruction.
You see, tomorrow, if he files a petition, you ask him, if he files a petition, okay, the partnership. Now the partition is not in exist. Can the court proceed? By simply to
Whether the liability,
the liability will be at the time of dissolution.
that
How the liability has to go to these partners. Not him, the other partners. So the liability, what happens in the dissolution by the, what is the effect of dissolution? See, it will be here. In settling the accounts of the firm after dissolution, the following rules shall be subject to the agreement. Losses including so and so, so and so. Assets of the firm, including any sum contributed by the to make deficiency of the people, shall be applied to the following manner. Then, how you are going to do against them is given under Order 30. CPC, follow the spirit to that effect. But his registration, I don't know how you are going to keep on asking for changing. You are allowing it, why you are not allowing it? But if that cannot be a reason.
as per the manual of the contract act, page 28, affidavit, that H and J locally is required to submitted by the contractor for placement in the mail related to individual. Where? Page 27, 27, when it is given the relevant data. Page 28, he is not filling the H and J, page 20. Submitted by the contractor for enlistment in the MES.
Which one?
H and J. H and J.
Affidavit from the contractor that there is no government use recovery, it's still to there is a need to be. See, that is a different aspect. I'm not on that. But he wants an enlistment.
Enlistment, MES now.
So it will be an enlistment, it's a new enlistment. So without submitting that document, he cannot. That is your case.
With your Lordship, I have filed the opposition affidavit in a reply under their opposition. I have pledged it, first of all, that there is no use. It is under arbitration. It has to be established. And in this particular case, I have also counterclaim. And this is under process. So secondly, there is
Because whether there is use or not, this court is not going to decide in this matter.
because I know because
When they say that there is a deed,
the
why
government,
should this court interfere?
that is their claim only, and it has not been established in the arbitration process. It is under process. So there is not, they cannot claim that there is dues against me until and unless it is established in the arbitration process.
That's why he was not giving affidavit swearing that I have no government bill. Then
No, no, there is
Submit
a requirement.
Have you given that?
that affidavit.
Have you given that affidavit that you have no goods?
Your Lordship, I have given them every reply in my.
Not here.
affidavit reply.
There.
Yes, I have claimed, I have said that I have.
Have you given this particular document?
Yeah.
Lecture 8, documented 8 to them?
In reply, I have said that there is a claim, I don't accept it because the case is sub judice, it is under arbitration process. So until and unless it is established in arbitration process, it is their claim only and it is not against me. It has to be established in arbitration.
So
process.
why you are not giving that affidavit?
I have given your Lordship. I have
Not
given
here, not here.
Here also.
There.
Here I also given your Lordship. That in my reply, I am telling you.
That affidavit.
I'm not, I'm
give me
concerned. Have you given this affidavit, annexure H? Have you given this affidavit there?
Lordship, in reply, I am just.
Not reply, yes. They say that they have not submitted this document, which is.
I have submitted the document, Your Lordship.
My
Refer
objection
document.
not submitted.
Their only objection is that there is dues against me. That I have replied that is in under sub judice under arbitration process. Second, they have said that the party has gone to arbitration in court more than once over. And if the court doesn't hold their views, in my case, all the arbitrator has been appointed, and then it is there is an arbitration clause in the contract. So we have the liberty to go to the court if if my contract is cancelled, they can go to the court for arbitration. I too have the right to go for, and for that I have used my power to go to the court.
So therefore, now you don't want to go for an enlistment, you want a conversion. You want the conversion. Where is the conversion permission? Show me. Have you enclosed it?
Lordship, I couldn't understand what conversion means.
Have you enclosed the conversion procedure?
Your Lordship, I am submitting here the statement of pleading in defense and to the arbitrator by them.
Where is the procedure?
Just a minute, Your Lordship. I am-
Now, heard Mr. Twain through the legal counsel. Heard Mr. Sanjay Sharma. Sanjay Sharma. The petitioner in person, who is the proprietor of
Your Lordship, I am
a
submitting.
firm in the name and style of MS Meghalaya Engineers and Agencies. I've also heard Mr. S.S. Roy, the learned counsel appearing on behalf of the respondents. The case of the petitioner herein is that the petitioner written various communication. In the case of the petitioner herein is that the petitioner, the firm MS Meghalaya Engineers and Agency was earlier a partnership firm. However, the same was dissolved upon the death of one of the partners. And the retirement of the other partner. And presently the firm, namely MS Engineer, Meghalaya Engineers and Agency, is a proprietorship firm. The petitioner had submitted various correspondences for enlisting the petitioner's firm, the petitioner firm, by converting it from partnership to proprietorship. The same having not been done by the respondent authorities. The petitioner has approached this court by filing the present petition. The record reveals that an affidavit in opposition has been filed by the respondent, wherein it is mentioned that a contract was awarded to the petitioner firm, but the sale was cancelled. And there are government dues amounting to rupees 68,60,132. Inasmuch as the contract was cancelled at the risk and cost of the petitioner firm. It is further mentioned that the Manual of Contracts 2020, and more particularly para 1.5H, bracket H and J, stipulates as the documents required to be submitted for reconstitution of the firm and it is the specific case of the respondents that the said document are not being submitted. The question of enlisting the firm does not arise. The petitioner have also filed an affidavit in reply, wherein the petitioner have stated that the proceedings have been initiated against the demand made by the respondents before the arbitrator, which is presently pending. It is also being mentioned in the said affidavit in reply that there is also a counterclaim filed by the respondents in the said arbitration proceedings.
My counterclaim. They have the claim, I have the counter.
That the respondents have approached the arbitral tribunal seeking recovery.
We have not approached.
He had approached. He had approached. Then what is wrong? What I said, he have filed a counterclaim.
We have not filed a complaint.
He said in the claim, he had a counterclaim.
How can that be?
Is your lordship,
Filed a and the said proceedings are pending. The question therefore arises as to whether the petitioner herein is entitled to be enlisted as a proprietorship firm without submission of the documents and provide submission of the documents which is required in terms of para 1.5 bracket H and J of the Manual of Contracts 2020. The learning council, taking into account the above, this court directs the petitioner to, taking into account the above, this court observes that without there being a challenge to the Manual of Contracts para 2000, Manual of Contracts 2020 para 1.5 H and J to be arbitrary, there cannot be any directions issued upon the respondents for enlisting the contractor and enlisting the petitioner firm Mr. Sanjay Sharma, the petitioner in person submits that you do the needful. It's the matter, how much time? Anytime.
Your lordship, there is one wrong fact is going on in the report. I have given the required document. It has been accepted by them.
Valid, it's not happening, not like.
Your lordship, any date in next week or two.
It's the matter, not to go. This type of matter needs to be dismissed. 29th of May.
29th of May.
For filing affidavit in reply.
The learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file an affidavit in reply. Considering the above, list this matter on 15th of June 2026. In the meantime, the affidavit in reply will be filed.
People, the accommodation was, we have communicated, but they have not sent, they, so 2 weeks time also.
What is the matter about?
The parties, I got, admitted as a.
The whole matter.
There is no admission also.
Police,
Police.
let them file instructions. Mr. K. Gogoi, the learned additional senior government advocate, submits that 1 week time may be granted to him for providing the obtaining necessary instructions as to whether the petitioner is entitled to any amount as claimed. List the matter again on 20 May 2026.
They have filed it, they have admitted the amount. Well, yes, today we have filed the affidavit. And, not all.
How much you have?
65 lakhs, 60 lakhs admitted. Out of 65 lakh claim amount, 60 in conjunction. Paragraph 7.
The police was admitted. Police was paragraph
7. Paragraph 7, they have admitted 5 also, 5-3. Sorry, 6-3. Page number 1.
paragraph 6 and 7. Kukui. 6 months.
Right. Lordship,
Yes, why no payment has been made? PNRD? Who has to pay?
as so was the 3.
New notice upon response number 9.
9.
Who is he?
He is the CEO, Lordship.
Why you are making the response number 9 a party?
Lordship, he was not made party in the initial while filing the petition. Lordship.
Why he has been made a party?
Lordship, some communication is there between the authorities, Lordship, and the last article that he was not made party. That's why, Lordship, he was made party. Otherwise, Lordship, the claim of the petitioner is admitted in the year 2019, Lordship, at page 91. By the erstwhile project director, Lordship, at para 4, Lordship.
Yeah, affidavit. What do they say in the affidavit?
Lordship, now in the affidavit, we are saying they form some new committee to
to verify the pending liabilities of the petitioner lordship. At page 110 lordship, the Joint Commissioner written to the Chief Executive Officer lordship. And the Joint Commissioner in RD
But
asking-
Mr. Counsel, why have you made the chief executive officer a party?
lordship, in the year, lordship, he admitted my claims lordship.
So his admission would not do. My question is, why at a late stage you have made him a party?
Lordship, at the initial time, lordship,
You do one thing. You file an affidavit in reply. And in the affidavit in reply, you bring these averments. By way of certain averments, bring it out here. You have not filed an affidavit in reply to the affidavit in opposition.
Yes.
You file an affidavit in reply, bring that. Then only you can bring the CEO. You see, normally when you implead, you don't implead just for the sake of it. You have to make certain allegations or statements against that person concerned. Otherwise, making him a party makes no sense.
yes, I'll
Mr. So-and-so, who appears on behalf of the petitioner, submits that 2 weeks' time may be granted to the petitioner to file a reply to the affidavit in opposition. List this matter again on 25th of May 2026. In the meantime, the reply be filed. Yes, what is this? Affidavit have been filed. Okay, then we keep it for final response on some day. When urgency, no urgency.
From my side, yes, from their side.
You don't have urgency.
Your lordship
The
may
case of
recollect-
blacklisting.
No, my lordship may recollect, my lord, the tender, one of the eligible bidders was blacklisted by another company, my lord, IGGL. So they had come against the consideration of that particular bidder in the first round of litigation. I mean, the evaluation, he was out of the fray. So now they have challenged the evaluation process also in the second round of litigation. So there are 2 writ petitions by each one. That will be considered for final disposal.
Because I passed one order
Yes.
where they put up question out there as to how that particular respondent number 5. He was already blacklisted, how he could get it.
That was the first litigation, first.
And I did not stay there. Taking into account your submission made to the fact that if the earnings do not come within the PSU or something to that effect. And their submission that it is a part of that globe marriage.
That particular bidder is out of the picture.
That is out. So
He is
the
a-
petition will become infructuous.
Now they are questioning, because they are also out by that, they are questioning the evaluation process.
It's okay,
In the
but
second
this petition has become infructuous.
First one was quite lucrative.
It's okay. Second will remain, but first one has become infructuous. Why should we make the lot thicker?
That is for them to say what that's.
You don't say we dismiss it. It is infructuous, the first one. If this respondent number 5 is no longer.
One thing will remain. If they succeed in the second round of litigation, the second writ petition, then the first one will be revived.
Right.
Because they are challenging what has happened. When the tenders are opened in the portal, a list goes out. But then, as per the tender conditions, we are required to evaluate it further. Then the position has changed. So if they are successful in the second writ petition, then this party, the blacklisted party will again come in.
But why, but why was the respondent number 5 out of the 3?
As far as we are concerned, he is out.
Why?
Because after the detailed evaluation, he came out 5th one. We are supposed to consider only 3 bidders. As per the tender conditions, everyone will do the work at the L1 rate.
And the petitioners are?
L4 and L5. Petitioners and that particular bidder, they are out of the
4 and 5. But he has not challenged the being 5. Then what do you mean?
Only thing, that is what I'm saying.
No. He then also becomes 4.
He will become 3 then.
Why?
That blacklisted bidder will become 4.
Because they challenge those other 2. Yes.
So Lordship will not dismiss it today.
Because of them.
Because of them.
But they are not challenging 5.
No,
The 5 is not here.
the blacklisted bidder,
It's 5 here.
he was L3 in the initial. Now, after the detailed evaluation, he has become L5.
So therefore, 5 is not here. 5 is not here.
Not in the play. But now, if they succeed in the second petition,
My question is 5 is not here. Not a petitioner here.
no.
So therefore, why at their instance I keep the right of 5 alive?
That is their one.
Anyways, they are above the 5.
They are above the 5, but
So
initially they are not.
that is your headache. So therefore, you are trying to say that if the petitioner wins in the second set of petition, 5's right will be died.
Yes.
That is your lookout. You file a petition.
No, I will not fight, man.
Then what will be?
I am not concerned with that, man.
So then they are not concerned because 5 is out. You want 5 to be there in the play. Then what remains in the first place?
But my lord, then after your lordship, it is also in the matter. They altered the price. The price bid was paid. So reopen for the second time.
Anyway, but they have opened. Now are you now, Mr. Decca, are you still holding to this price bid which you held it subsequently?
Yes, ma'am. It is the same price bid, man. The tender
So
itself
you are not sure.
No, man. The tender itself stipulated that the price bid quoted had to be multiplied by certain factors, man. I'll demonstrate that.
So
That is how the position changed.
So therefore, each price bids which are there, you which stand with
Yes,
it.
I stand by.
It is not on the basis of my order.
No.
It is on the basis of
Tender
the
content.
evaluation.
Tender content.
My lord, the second round, that W51, we were agreed by the authorization of the price. The second time the price bid was reopened. So we came with this price petition.
Second time, is that the only ground?
The second.
No, we take it up for final disposal.
Lordship will take it up for final. That is not the correct.
That is the ground we can finish up. You can very well do it till you issue the contract.
Contracts have already been issued, man. They are running.
No, till you issue the contract, you can always evaluate or do whatever it is.
We have done it strictly
There is no
according to the
right.
tender, man. I can demonstrate that.
Okay, let us take up for final disposal. Argue.
Lordship will take it.
No, now. Let us take it now.
One, sometime.
Why?
The second, the WPC identical matter.
Okay, we'll consider her matter later on. First, you argue your matter. Why? Let's keep it off. These are simple matters. What do you say, Mr. Decca? Unnecessary. Having a cloud over a particular contract. These litigations are clouds. So we should remove those clouds and have a
Clear sky.
blue weather. No?
Clear skies. Anyway, but if she is having difficulty, I leave it.
Can there be a difficulty? The materials on record show that the pleadings amongst the parties are complete. Considering the above, urgency, no urgency, means we are not arguing no urgency, we'll have it in the month of August. Above, this matter for final disposal on 13th of August 2026.
Matter pertains to non-payment of contractor bill. Page 15 is the liability statement.
Which department?
Public Union and Water Resource. Page 15.
You verify.
Lordship, we have filed affidavit stating that there is balance of 3 lakh something, your lordship.
Huh?
20 lakh 86,000 already paid, your lordship.
Then
And others, there is, I have stated that there is some audit objection, your lordship. There is some audit objection from the accountant general. That's why central government could not release their fund, your lordship. They have filed affidavit today also. Today, we have filed affidavit. We also stated the same thing now.
In page number 26, madam, it is stated regarding the audit observation objected. 26, madam. Para number 8, madam. Promoter receive a funding proposal from what? 26, para 8, madam.
we have not submitted the reply. That is the reason this has happened.
That's one, your lordship, because the bill of the petitioner is also of 2012, your lordship.
Have they given you a copy?
That's now I have issued.
Okay.
This is a small amount, lordship. 3,26,000.
But Ms. Soilful, the learned counsel appearing on behalf of the petitioner. Ms. Hardeka appears on behalf of the Water Resource Department. Ms. Agay appears on behalf of the respondent number 1 and 2. The petitioner has filed the instant proceeding claiming an amount of rupees 3,26,829, which is the balance payable in respect to a contract work pertaining to in respect to 3 contract works. Isn't it? In respect to 3 contract works. The 3 contract works. The details which is available at page 15 of the petition. The records reveal that an affidavit has been filed by the respondent, number 4, stating inter alia that out of the total value of the work of rupees 24,13,204, the petitioner have already been paid an amount of rupees 20,86,375. However, on account of non-clearance from the Office of the Accountant General, the necessary demand could not be placed to the respondent number 2 for releasing the balance payment. The record further reveals that an affidavit has been filed on behalf of the respondent number 1 and 2, wherein it is categorically mentioned at paragraph number 8 that there has been an audit disallowance of rupees 19,55,000, which was raised by the Accountant General Audit. Accordingly, certain observations have been issued to the Water Resource Department of the Assam on 26/8/2024 and 11/9/2025. However, there has been no reply received from the Water Resource Department, and as such, the amount of rupees 19,55,000 could not be sanctioned, isn't it? In respect to the scheme number AS 92. Ms. Ardeka, the learned standing counsel of the Water Resource Department, submits that she has received a copy of the affidavit in opposition and would obtain instructions from the Water Resource Department instructions as to why the observations so made by the Brahmaputra board, as mentioned in the affidavit in opposition filed by the respondent number 1 and 2, have not yet been addressed by the Water Resource Department. Taking into account the above, list this matter on 15th of June 2026 for an update. What is this?
Please, Your Lordship. And then we get a lordship. Then the challenge the order, Lordship, it's number 20/11/2025.
What are you challenging?
We did pending of contempt petition, Lordship, this order.
4/1/2025. Where is that order?
Order, Lordship, it plays the 100.
Page number 100.
Order, Lordship, please.
In pursuance to the inquiry commission immunity right in connection with the orders passed by insurance and contempt case number where the following opinion in order to verify the lead supreme. Then why you challenging this?
Yes, kindly come to Lordship, page number 76, Lordship. If you file by the page was said contempt. Then the 76, Lordship.
And in big in the amount of rupees so and so.
So there is no further payment to be made.
Yes.
So how do this court decide this matter?
Already the during pending of contempt, drop this contempt, Lordship. Subsequently, Lordship, I have the order, Lordship, page number 11%.
Why haven't you filed affidavit?
Sure, because we are relying on the materials which are already part of the writ petition, Lordship. We are relying on the materials which are already part of the writ.
You are not going to file affidavit.
Sure, because
Are you filing your affidavit or not? Tell us. Don't come up with all these submissions before this court. I'm asking you, are you going to file the affidavit or not? If you don't file, don't file. We'll make it very clear. You are not filing it, then you will be relying on the materials. Very well. Also, you are not filing. Mr. Gogoi, are you filing any affidavit? Yes. Mr. R.R. Gogoi, the learned standing counsel of the Forest Department, and Mr. N.R. Sharma, the learned counsel appearing on behalf of the BTC, submits upon instructions that the respondents would not be filing any affidavit in the present proceedings. And they would be relying on the documents which have been filed by the petitioner to the affidavit in opposition to the writ petition. Accordingly, list this matter again on (25) 2026 for admission, comma, for final disposal, full stop. Taking into account that no affidavit has been filed, comma, by the respondents, comma, the instant writ petition shall be disposed of purely on the basis of the materials on record. You understand the meaning of the word?
Answer, Lordship, because in that contempt petition, Lordship. we are
Okay, no,
validating.
it's okay. If he's alleging anything, we can apply the doctrine of non-reversals.
May I note that this non-payment of contractors for an amount of 2,98,000. Instruction is still awaited, Lordship. Instruction are awaited, Lordship.
Huh?
Instructions are awaited.
New matter.
Matter and the work orders of 2017.
But 2017, you are filing in 2026. Mr. R.R. Gogoi, the learned counsel appearing on behalf of the respondent submits that the petitioner herein is seeking certain amounts, claiming the same to be payable to the petitioner in respect to the work orders of the year 2017 by filing the present writ petition in the year 2026. The learned counsel for the respondent submits that taking into account that the writ petition has been filed almost a decade after, it is very difficult on the part of the respondents to obtain instructions. In that view of the matter, the writ petition stands adjourned to be listed on 7th of September 2026. In that, the respondent shall file the affidavit on or before 24th of August 2026 as to whether the petitioner is entitled to the amount so claimed, or in addition to that, the respondents would be at liberty to also state on affidavit that there are no materials available with the respondent department. In addition to that, comma, full stop. The above directions shall not, however, preclude the petitioner respondents to take a stand that they have not been able to trace the materials to verify as to whether the petitioner is entitled to the said amount, taking into account that the writ petition has been filed almost a decade. Each.
My lord, kindly, annex 4, my lord, 19, my lord. This is very recent, my lord.
After long matter, I now have stopped till 2021. Without looking, I pass order. 2021 earlier? No. Therefore, Mr. Gogoi, you see, I'm holding bench 4, you have only one motion on a motion block.
Well, here, my lord, the taken of the petitioner committee, contempt will be 2023. That's why it is not being delayed.
But can I take up this matter? I've not been taking up these pharmacy matters.
Well, here, my lord, the cancellation of registration is not on the challenge.
Okay.
That part lordship was dealing at it.
Ah.
But they will be at liberty to challenge it. No legal. I'm providing a copy to all.
Mr. B. Gogoi, the learned Additional Advocate General as well as the Standing Council of the Health and Family Welfare Department submits that the instant writ petition has become infructuous in view of the fact is infructuous taking into account that the registration of the petitioner's license, pharmacy license had already been cancelled by a notification dated 15/6/2023. The learned counsel, appearing on behalf of the petition respondents, further submitted that without a challenge to the said notification dated 15/6/2023, this court may not like to entertain the instant writ petition. This court had duly perused this order, perused the notification dated 15/6/2023, which is kept on record and marked with the letter X. A copy of the said notification was also handed over to the learned counsel appearing on behalf of the petitioner, along with the cancellation notice which was issued to the petitioner dated 4/5/2023. It is the opinion of this court that without there being a challenge to the said cancellation of the petitioner's license, no effective directions can be passed in the instant proceedings. Accordingly, the writ petition stands dismissed without prejudice to the petitioner to assail the notification dated 15/6/2023, if so advised. Okay? Yes. Oh, his last item. Item number 6, isn't it? And the service is not complete as regards the respondent number 6. So the counsel appearing on behalf of the petitioner submits that he would like to take service upon the respondent number 6 by way of dusty, routed through the registry of this court. So taking into account the said submission, the learned counsel appearing on behalf of the petitioner directed to take service upon the respondent number 6 by way of dusty, routed through the registry of this court and file an affidavit of service on or before the next date. List the matter again on 15th of June 2026. The service be effected by way of dusty by the petitioner on or before 3rd of June 2026. Interim order passed earlier shall continue till the next date. Then respondent number 6 was there. Yes, Mr. Das. Any matter?
Just out.